In today's digital age, information is constantly being generated, shared, and stored electronically. From emails and text messages to social media posts and cloud-based documents, the volume of electronically stored information, or ESI, has exploded in recent years. This digital revolution has significantly impacted various fields, including the legal realm. Traditional legal practices relied heavily on paper documents and physical evidence. However, the proliferation of ESI has necessitated a shift towards electronic discovery, commonly known as e-discovery. E-discovery encompasses the processes and procedures involved in identifying, preserving, collecting, reviewing, and producing electronically stored information in response to legal proceedings or investigations. The importance of e-discovery stems from the fact that ESI can serve as crucial evidence in a wide range of legal matters, from contract disputes and intellectual property cases to criminal investigations and regulatory inquiries. ESI often holds the key to uncovering the truth and ensuring a just outcome. As the volume and complexity of ESI continue to grow, mastering e-discovery has become paramount for legal professionals, IT experts, and anyone involved in the legal process. Understanding the intricacies of e-discovery is essential for effectively navigating the legal challenges and opportunities presented by the digital age. While e-discovery and digital forensics are distinct disciplines, they are closely intertwined and often overlap in practice. Digital forensics focuses on the identification, preservation, analysis, and presentation of digital evidence for investigative purposes, typically in criminal cases. On the other hand, e-discovery is broader in scope, encompassing the entire life cycle of ESI in legal proceedings, including civil cases. In essence, digital forensics can be viewed as a specialized subset of e-discovery, providing the technical expertise and tools necessary to extract and analyze digital evidence. In the context of e-discovery, digital forensics techniques may be employed to recover deleted files, analyze internet history, or examine metadata for timestamps and authorship information. This forensic analysis can provide valuable insights and support legal strategies in e-discovery cases. The relationship between e-discovery and digital forensics highlights the increasing importance of technology in modern legal practice. As technology continues to evolve, so too will the methods and tools used in these disciplines, demanding continuous learning and adaptation from legal professionals. E-discovery is not merely a technical exercise. It is governed by a complex web of rules, laws, and regulations. Understanding this legal framework is crucial for ensuring that e-discovery processes are conducted in a defensible and legally sound manner. At the federal level, the Federal Rules of Civil Procedure, or FRCP, provide a comprehensive set of guidelines for e-discovery in civil litigation. These rules address key aspects such as the duty to preserve ESI, the scope of discoverable information, and the procedures for handling electronically stored information. In addition to the FRCP, various other federal laws and regulations impact e-discovery, including the Federal Rules of Evidence, the Stored Communications Act, and the Electronic Communications Privacy Act. These laws address issues such as the admissibility of electronic evidence, the privacy of electronic communications, and the procedures for obtaining electronic data from third parties. Navigating this complex legal landscape requires a thorough understanding of the applicable rules and regulations, as well as the ability to apply them to specific e-discovery scenarios. Failure to comply with these legal requirements can have serious consequences, including sanctions, adverse inferences, and even dismissal of a case. While rules and regulations provide a framework for e-discovery, case law plays a critical role in interpreting and applying those rules to real-world situations. Judicial decisions in e-discovery cases have established important precedents that guide practitioners and shape the evolving landscape of this field. One notable example is the Zubalake versus UBS Warburg case, a landmark e-discovery case that addressed the duty to preserve ESI and the consequences of spoliation. The Zubalake decisions established a series of guidelines for preservation, including the trigger date for the duty to preserve, the scope of preservation obligations, and the factors considered when assessing spoliation sanctions. Another significant case is the Pension Committee of the University of Montreal Pension Plan versus Bank of America Securities, LLC, which addressed the proportionality principle in e-discovery. The Court and Pension Committee emphasized that discovery requests must be proportional to the needs of the case, considering factors such as the importance of the issues at stake, the amount in controversy, and the parties' relative access to relevant information. These cases, along with numerous others, illustrate the dynamic nature of e-discovery law. As technology advances and new e-discovery challenges arise, courts continue to grapple with complex issues and establish precedents that shape the future of this field. Staying abreast of these developments is crucial for legal professionals involved in e-discovery. Section 5. Understanding the Electronic Discovery Reference Model, or EDRM. The Electronic Discovery Reference Model is a widely recognized framework that provides a structured approach to managing the e-discovery process. Developed in 2005, the EDRM outlines the typical stages of e-discovery, from information governance to presentation, offering guidance and best practices for each stage. The EDRM consists of 8 stages: information governance, identification, preservation, collection, processing, review, analysis, and production. Each stage represents a distinct phase of the e-discovery lifecycle, with specific tasks and considerations associated with each step. The EDRM is not intended to be a rigid, linear process. In practice, the stages may overlap, and the specific steps taken may vary, depending on the nature and complexity of the case. However, the EDRM provides a valuable framework for understanding the key components of e-discovery and developing a defensible and efficient e-discovery strategy. By adhering to the principles and best practices outlined in the EDRM, legal teams can streamline their e-discovery efforts, reduce costs, minimize risks, and ultimately enhance their ability to effectively leverage electronically stored information in legal proceedings. The EDRM serves as a roadmap for navigating the complexities of e-discovery and ensuring that ESI is handled appropriately throughout the legal process. Section 1. E-discovery and litigation, a targeted approach. In the realm of litigation, e-discovery plays a pivotal role in uncovering the truth and resolving legal disputes. Unlike traditional discovery, which often involved sifting through mountains of paper documents, e-discovery focuses on the identification, preservation, and production of electronically stored information. One of the key distinctions between e-discovery and digital forensics lies in their scope and objectives. While digital forensics often involves a broader investigation to uncover digital evidence related to a specific incident, e-discovery in litigation is typically more targeted. In litigation, parties use e-discovery to request and obtain specific ESI from their opponents that is relevant to the claims and defenses in the case. This targeted approach ensures that the discovery process remains focused on the legal issues at hand, preventing unnecessary delays and expenses associated with reviewing irrelevant information. For instance, in a contract dispute, the parties might use e-discovery to request emails, contracts, and other electronic communications related to the formation, performance, or breach of the contract. By focusing on the specific ESI that is most likely to shed light on the disputed issues, the parties can streamline the discovery process and focus their efforts on the most relevant evidence. Section 2. Digital Forensics. Unveiling the Digital Trail within e-discovery. While e-discovery in litigation often involves a targeted approach to obtaining specific ESI, there are instances where the expertise of digital forensics professionals becomes invaluable. Digital forensics, with its specialized techniques for recovering deleted files, analyzing internet history, and examining metadata, can provide crucial insights that would otherwise remain hidden. For example, in a case involving allegations of intellectual property theft, digital forensics experts might be called upon to examine the computers and other devices of the alleged infringer to determine if any proprietary information was accessed, copied, or transmitted without authorization. The forensic analysis might involve recovering deleted files, analyzing internet browsing history, or examining timestamps and file properties to establish a timeline of events. This type of evidence can be instrumental in proving or disproving allegations of wrongdoing. Moreover, digital forensics can play a vital role in cases involving spoliation of evidence, where one party is accused of destroying or altering ESI that is relevant to the litigation. Forensic experts can examine computers and other devices to determine if any files have been deleted, modified, or hidden, and they can often recover deleted data, providing valuable evidence for the opposing party. Section 3. Defining the scope. From keywords to concepts. One of the initial challenges in e-discovery is defining the scope of relevant electronically stored information. With vast amounts of data often involved, it is crucial to establish clear parameters for what information is discoverable and what is not. Traditionally, keyword searches have been used to identify relevant documents based on specific terms or phrases. However, keyword searches can be limited in their effectiveness, often resulting in either too many irrelevant results or missing crucial documents that do not contain the specific keywords used. To address these limitations, more sophisticated search techniques, such as concept searching and technology-assisted review, or TAR, have emerged. Concept searching uses algorithms to identify documents that are conceptually similar to a set of sample documents, even if they do not contain the exact keywords used in the search. This approach can be particularly useful for identifying documents that use synonyms, variations in phrasing, or discuss the same concepts using different terminology. Technology-assisted review, also known as predictive coding, leverages machine learning algorithms to analyze and categorize large volumes of electronically stored information, identifying documents that are likely to be relevant to the case. This technology can significantly reduce the time and cost associated with manual document review, while also improving the accuracy and consistency of the review process. Section 4. The power of metadata. Unveiling hidden insights. Beyond the content of electronic documents, metadata provides a wealth of information that can be invaluable in e-discovery. Metadata refers to the data about data that is automatically generated and associated with electronic files. This hidden information can reveal details about the creation, modification, access, and transmission of files, providing crucial insights into the who, what, when, and where of electronic communications and document creation. For instance, metadata can reveal the author of a document, the date and time it was created, modified, and last accessed, and the computer or device used to create or edit the file. It can also track the history of changes made to a document, showing who made the changes, when, and what those changes were. This information can be crucial in verifying the authenticity of documents, establishing timelines of events, and identifying potential witnesses or custodians of relevant information. In some cases, metadata can even reveal attempts to conceal or alter evidence, such as changing file names or timestamps. Section 5. Navigating the legal landscape. Rules and regulations in e-discovery. As with any legal process, e-discovery is subject to a complex web of rules, regulations, and case law. Understanding this legal framework is essential for ensuring that e-discovery is conducted in a defensible and legally sound manner, protecting the rights and interests of all parties involved. The Federal Rules of Civil Procedure, which govern civil litigation in federal courts, provide a comprehensive framework for e-discovery. These rules address key aspects of the e-discovery process, including the duty to preserve electronically stored information, the scope of discoverable information, and the procedures for handling electronically stored information. Failure to comply with these rules can have serious consequences, including sanctions, adverse inferences, and even dismissal of a case. Therefore, it is crucial for legal professionals to stay abreast of the latest developments in e-discovery law and to ensure that their practices align with the evolving legal landscape. In addition to the Federal Rules of Civil Procedure, various other federal laws and regulations, such as the Stored Communications Act and the Electronic Communications Privacy Act, impact how electronic data is accessed, stored, and disclosed during legal proceedings. Section 6. The Federal Rules. Setting the stage for e-discovery. The Federal Rules of Civil Procedure, or FRCP, play a pivotal role in shaping the e-discovery landscape. These rules establish a framework for managing electronically stored information, or ESI, throughout the litigation process, ensuring fairness, efficiency, and proportionality in discovery. Rule 26, for instance, addresses the duty to preserve relevant ESI. This duty arises when litigation is reasonably anticipated, and it requires parties to take reasonable steps to preserve ESI that may be relevant to the case. Failure to do so can result in spoliation sanctions, which can range from monetary fines to adverse jury instructions. Rule 34 governs the production of ESI, outlining the procedures for requesting and obtaining electronically stored information from opposing parties. The rule allows for requests for specific documents or categories of documents, as well as for data in its native format or in a reasonably usable form. Furthermore, Rule 37 addresses sanctions for discovery violations, including the failure to preserve or produce ESI. These sanctions are intended to deter parties from engaging in improper or dilatory discovery practices, and to ensure a level playing field for all parties involved in the litigation. Section 7. A global perspective. E-discovery beyond borders. In an increasingly interconnected world, legal disputes often transcend national boundaries, adding another layer of complexity to e-discovery. With data stored on servers across the globe, navigating the legal frameworks and cultural norms of different jurisdictions becomes paramount. The European Union's General Data Protection Regulation, or GDPR for instance, has significant implications for e-discovery involving data. Subjects located in the EU. The GDPR imposes strict requirements on the collection, processing, and transfer of personal data, and it grants individuals greater control over their personal information. Similarly, data privacy laws in other countries, such as Canada's Personal Information Protection and Electronic Documents Act, or PIPEDA, and Australia's Privacy Act, also impact how e-discovery is conducted internationally. Understanding these international laws and regulations is crucial for organizations operating in a globalized marketplace, as failure to comply can result in hefty fines, reputational damage, and legal challenges. Section 8. The Sedona Principles, guiding e-discovery practices. In the ever-evolving realm of e-discovery, the Sedona Principles serve as a valuable resource for legal professionals navigating the complexities of electronically stored information. Developed by a group of judges, lawyers, and technologists, these principles provide guidance on best practices for managing e-discovery, promoting cooperation, and ensuring fairness in the discovery process. The Sedona Principles emphasize proportionality, urging parties to tailor their discovery requests and responses to the specific needs of the case, considering factors such as the importance of the issues, the amount in controversy, and the relative access to information. They also stress the importance of cooperation between opposing counsel, advocating for early communication and collaboration to address e-discovery issues, and develop a mutually agreeable discovery plan. By adhering to the principles outlined in the Sedona Principles, legal professionals can foster a more efficient, cost-effective, and predictable e-discovery process, while also minimizing the risk of disputes and sanctions. The long arm of the law, federal rules, and e-discovery. In the digital age, ensuring the integrity and discoverability of electronically stored information, or ESI, is paramount. The United States has established a comprehensive framework of federal rules to govern e-discovery. These rules ensure ESI is handled fairly, protecting all parties involved. The Federal Rules of Civil Procedure, or FRCP, provide guidelines for managing ESI in civil litigation. They address key aspects like preserving relevant ESI and producing electronic documents. Other laws, like the Federal Rules of Evidence and the Electronic Communications Privacy Act, regulate electronic evidence and privacy. The Federal Rules of Civil Procedure guide e-discovery in the U.S. They provide a framework for managing ESI in civil litigation. Key aspects include the duty to preserve relevant ESI. Rule 26F mandates early discussions on ESI preservation. Failure to preserve can lead to sanctions. The scope of discoverable ESI is also crucial. Rule 26B 1. Ensures discovery is proportional to the case needs. Beyond civil litigation, e-discovery in criminal proceedings. While the Federal Rules of Civil Procedure, or FRCP, provide a comprehensive framework for e-discovery in civil litigation, the rules governing e-discovery in criminal proceedings are more fragmented and evolve from a patchwork of statutory provisions, case law, and procedural rules. Nonetheless, the same fundamental principles of fairness, proportionality, and preservation apply in both civil and criminal contexts. In criminal cases, the prosecution bears the constitutional duty to disclose exculpatory evidence to the defense, including electronically stored information. This duty stems from the Fifth Amendment's Due Process Clause, which guarantees a fair trial, and it requires the prosecution to turn over any evidence that tends to prove the defendant's innocence or casts doubt on their guilt. The Federal Rules of Criminal Procedure, or FRCRP, also address certain aspects of e-discovery, albeit not as comprehensively as the FRCP. For instance, Rule 16 governs discovery in criminal cases, outlining the types of information that the prosecution and defense must disclose to each other, including documents and tangible objects. However, the FRCRP do not explicitly address e-discovery, and courts have grappled with the application of traditional discovery rules to electronically stored information in criminal cases. As technology advances and the volume of ESI in criminal cases continues to grow, it is likely that the rules governing e-discovery in criminal proceedings will continue to evolve to keep pace with the changing legal landscape. Section 4. Safeguarding Privacy, the Electronic Communications Privacy Act. Balancing law enforcement needs and individual privacy is challenging in our digital age. Enacted in 1986, the ECPA regulates government access to electronic communications and data. It includes the Wiretap Act, the Stored Communications Act, and the Pen Register Act. The Wiretap Act governs interception of communications, while the Pen Register Act covers dialing and routing information. The Stored Communications Act governs access to stored communications like emails and texts. Section 5. Corporate Accountability and E-Discovery, the Sarbanes-Oxley Act. In the wake of high-profile corporate scandals that shook the U.S. economy in the early 2000s, such as Enron and WorldCom, Congress enacted the Sarbanes-Oxley Act of 2002, or SOX, to restore investor confidence and promote corporate accountability. While SOX primarily focuses on financial reporting and corporate governance, it has had a significant impact on e-discovery practices, particularly for publicly traded companies. SOX Section 802, known as the Corporate Records Tampering Provision, criminalizes the alteration, destruction, concealment, or falsification of corporate records with the intent to impede, obstruct, or influence a federal investigation. This provision has far-reaching implications for e-discovery, as it underscores the importance of preserving relevant electronically stored information, or ESI, even in the absence of pending litigation. Companies subject to SOX are required to implement robust record retention policies and procedures to ensure that they are preserving electronic documents and other records that may be relevant to a potential investigation by the Securities and Exchange Commission, or SEC, or other regulatory bodies. Failure to comply with SOX can result in severe penalties, including substantial fines, imprisonment of corporate officers, and delisting from stock exchanges. Consequently, SOX has prompted many companies to adopt more proactive e-discovery practices, such as implementing data retention policies, conducting regular data audits, and investing in e-discovery technologies to streamline the identification, preservation, and production of ESI. Section 6. Reaching across borders, the international reach of e-discovery laws. In today's global marketplace, legal disputes rarely stay within national borders. E-discovery now requires navigating a complex web of international laws and regulations. The GDPR, effective since 2018, profoundly impacts e-discovery involving EU data subjects. It imposes strict requirements on data collection, processing, and transfer, with hefty fines for non-compliance. The GDPR's data minimization principle limits the scope of data for discovery. The right to erasure challenges e-discovery by conflicting with data preservation duties. Section 7. Enron. A cautionary tale of e-discovery gone wrong. The Enron scandal, which unfolded in the early 2000s, stands as a stark reminder of the importance of ethical e-discovery practices and the devastating consequences that can ensue when electronically stored information is mishandled or destroyed. The collapse of Enron, once a Wall Street darling, exposed a web of accounting fraud, corporate malfeasance, and a systemic failure to preserve and produce relevant, electronically stored information. As investigators sought to unravel the complex financial schemes that led to Enron's downfall, they were confronted with a massive volume of electronic data, including emails, spreadsheets, and databases. However, their efforts were hampered by the destruction of key evidence, including the deletion of emails by Enron executives and the shredding of documents by Arthur Andersen, Enron's auditing firm. The destruction of evidence in the Enron case sparked outrage and highlighted the need for stronger legal protections for electronically stored information. The Sarbanes-Oxley Act, passed in the wake of Enron's collapse, included provisions specifically addressing the destruction of corporate records, reflecting a growing recognition of the importance of electronically stored information in corporate investigations and litigation. The Enron case serves as a cautionary tale for corporations and legal professionals alike, underscoring the critical importance of implementing robust e-discovery practices, including data retention policies, legal hold procedures, and employee training programs. Section 8. Case Law in Action. Shaping e-discovery practices. Federal rules provide a framework for e-discovery, but litigation refines these laws. Case law shapes e-discovery practices, guiding issues like duty to preserve information. Zubulake v. UBS Warburg, LLC, established when the duty to preserve arises. Pension Committee case emphasized proportionality in discovery requests. Section 9. The Ripple Effect. Enron's legacy on e-discovery. The Enron scandal, with its catastrophic collapse and the subsequent revelations of accounting fraud and document shredding, sent shockwaves through the corporate world and left an indelible mark on the landscape of e-discovery. In the aftermath of Enron, lawmakers, regulators, and legal professionals grappled with the need to strengthen safeguards for electronically stored information and prevent similar debacles from occurring in the future. One of the most significant legislative responses to Enron was the passage of the Sarbanes-Oxley Act of 2002, or SOX. While SOX primarily focuses on financial reporting and corporate governance, its provisions addressing the destruction of corporate records have had a profound impact on e-discovery practices. SOX Section 802, known as the Corporate Records Tampering Provision, criminalizes the alteration, destruction, concealment, or falsification of corporate records with the intent to impede, obstruct, or influence a federal investigation. This provision applies to both paper and electronic records, underscoring the importance of preserving all forms of electronically stored information that may be relevant to a potential investigation. Furthermore, SOX has prompted many companies to adopt more proactive e-discovery practices, such as implementing data retention policies, conducting regular data audits, and investing in e-discovery technologies to streamline the identification, preservation, and production of electronically stored information. Section 10. The Quest for Balance, Weighing Privacy and Justice in E-Discovery. Balancing justice and privacy in e-discovery is crucial as ESI grows exponentially. E-discovery uncovers digital evidence, presenting both opportunities and risks. It ensures a just outcome by providing access to hidden digital evidence. However, it can intrude on individual privacy, involving sensitive information. Courts seek guidelines to balance privacy and justice in e-discovery. Section 1. EDRM, a framework for navigating the e-discovery landscape. The Electronic Discovery Reference Model, EDRM, guides legal professionals through handling electronically stored information, ESI, in legal proceedings. Developed in 2005, the EDRM outlines stages from information governance to production, ensuring ESI is managed efficiently and in compliance with legal standards. Section 2, Stage 1, Information Governance, laying the foundation. Effective information governance minimizes e-discovery risks and costs by implementing clear data retention policies and robust security measures. Data mapping and strong security controls help organizations respond efficiently to discovery requests and protect sensitive ESI. Section 3, Stage 2, Identification, pinpointing the digital haystack. Identification involves determining the scope of relevant ESI and identifying key custodians through interviews and data mapping. Establishing a relevant date range and understanding data systems are crucial for developing an efficient e-discovery plan. Section 4, Stage 3, Preservation, holding the line against data loss. Preservation ensures relevant ESI is protected from alteration or deletion, often through legal hold notices. Steps like creating forensic images and suspending deletion processes are essential. Failure to preserve ESI can lead to serious legal consequences. Section 5, Stage 4, Collection, gathering the digital evidence. Collection involves gathering ESI from various sources while maintaining its integrity for court admissibility. Methods vary by data type and location, with a chain of custody log documenting the process. Section 6, Stage 5, Processing, transforming data into discoverable insights. Processing converts raw ESI into a standardized, searchable format, extracting metadata and removing duplicates. Techniques like OCR and data deduplication streamline the review process. Section 7, Stage 6 and 7, review and analysis, separating the wheat from the chaff. Review determines document relevance and identifies privileged information, often using technology-assisted review. TR. TAR prioritizes documents, reducing review time and costs, while improving accuracy. Section 8, Stage 8, Production and Presentation, delivering the digital story. Production delivers ESI to the opposing party in a structured format, organized for easy review. Effective presentation at trial uses visual aids and litigation support software to clearly convey key points. The Enron scandal highlighted the critical importance of sound e-discovery practices. The case exposed the vulnerabilities of traditional discovery methods in handling massive volumes of ESI. It underscored the need for new tools and legal frameworks to manage electronic evidence. One key takeaway from Enron was the importance of proactive information governance. Clear data retention policies and data mapping help organizations manage ESI efficiently. Enron's lack of control over ESI complicated discovery and raised concerns about evidence loss. The Enron case presented complex e-discovery challenges, testing legal frameworks and technology. Preserving vast quantities of ESI and reviewing it for relevance and privilege were major hurdles. The case led to the exploration of new technologies and legal precedents for electronic evidence. Section 4. Beyond Enron, the enduring impact on e-discovery practices. The Enron scandal spurred reforms in e-discovery rules and the development of the EDRM framework. It also led to the growth of the e-discovery industry, shaping current practices in managing ESI. Section 1. The evolving landscape of e-discovery. E-discovery is a dynamic and ever-evolving field. The rapid pace of technological advancement presents both opportunities and challenges. Sophisticated tools for managing and analyzing electronic data have emerged. Guidelines and best practices provide a framework for navigating this complex terrain. New forms of electronically stored information, like data from wearable devices and smart homes, are entering the legal realm. The cloud poses challenges and opportunities for e-discovery practitioners. Staying ahead requires ongoing education and embracing new technologies. Adapting to the evolving landscape ensures justice in the digital age. Section 2. The importance of adaptability and expertise. In the rapidly changing world of e-discovery, adaptability is not merely an asset, it's a necessity. Legal professionals and IT specialists must be prepared to navigate unfamiliar territory as new technologies emerge and the types of data relevant to legal matters expand. The ability to learn quickly, adapt to new tools, and apply existing legal frameworks to novel situations is paramount. Expertise in e-discovery goes beyond simply understanding the technical aspects of data collection and processing. It requires a nuanced understanding of the legal rules governing e-discovery, the ethical implications of handling sensitive information, and the strategic considerations involved in leveraging electronically stored information effectively in legal proceedings. Building a strong foundation in e-discovery requires a multifaceted approach. Staying abreast of legal developments, attending industry conferences, and pursuing certifications in e-discovery can provide valuable insights and enhance professional credibility. Collaboration with experienced e-discovery professionals, both within and outside one's organization, can foster knowledge sharing and provide access to specialized expertise. Ultimately, success in the field of e-discovery hinges on a combination of technical proficiency, legal acumen, and a commitment to continuous learning. By embracing these principles, legal professionals and IT specialists can ensure that they are well equipped to meet the challenges and opportunities presented by the ever-evolving world of e-discovery. Section 3. E-discovery, a cornerstone of modern justice. E-discovery is an indispensable pillar of the justice system. It transforms how legal disputes are investigated and resolved, from uncovering corporate fraud to exonerating the wrongly accused. Yet, it faces challenges like data volume and privacy laws. The legal profession must adapt to ensure fairness and justice. E-discovery is integral to our pursuit of justice in the digital age.